August 26, 2025. I would ask that the record reflect the subcommittee members that are present, as well as CRMC staff. First matter on our agenda is approval of minutes for the July 22nd, 2025 meeting. I believe we did get those, right? Yeah, Lisa sent those out. I saw those. I'd entertain a motion to approve those, please.
Motion to approve is submitted.
A motion has been made and seconded. Any discussion? Hearing none, all in favor, say aye.
Aye.
Motion carries. Staff report? Anything on?
No staff report tonight, Mr.
All
Chair.
right, first matter on the agenda would be the Spring Avenue extension. And I know Weekapaug Fire District is here for a presentation. Turn it over to you, sir.
For summary judgment.
Or for summary judge. Do you want to say anything for the record? Or?
No, I wanted to get going.
Okay.
Thank you, Mr. Chairman, and thank you to the subcommittee for the indulgence and letting us get set up. We're here on the fire district's motion for summary judgment tonight. The idea here is that the proponents lack evidence to enable them to prove their case before the subcommittee, and therefore a full trial is not required. The subcommittee has the ability to hear us tonight. This does not foreclose presentation or participation by the public. Public comment may still be provided separately from the hearing or trial on the merits. We want to remind the subcommittee of the legal standard. CRMC's determination that a parcel is a right-of-way shall be decided by, quote, substantial evidence. Intent to dedicate and acceptance must be clear. The proponents, excuse me, I've got to stand on the other side of this to read it. The proponents claim there was statutory or incipient dedication, but all they can rely on are assumptions and speculation, and I'll summarize their lack of evidence as follows. In their summary judgment papers, they say things like, quote, I don't think the Board of Highway Commissioners would have stamped the 1939 plat if Section 5 had been complied with. Spring Avenue extension must have been safe for travel. Spring Avenue extension was the sole route to the beach and was presumably rock-free. By logic, the developer had kept Spring Avenue clear of stumps, free of stumps and rocks. So according to the proponents, Spring Avenue extension must have been clean as required by the statute by logic, but not by proof. And what this subcommittee needs is proof, substantial evidence. I want to show you now the two crown jewels of evidence offered by two of the three crown jewels of evidence offered by the proponents. Two undated photographs. One in which they have imposed white arrows and circled what they claim is a person walking on the beach. We don't know the location of this photograph. We don't know that the person walking here is a Weekapauger or not. In fact, it's highly likely the person walking in this undated photograph is a Weekapauger or a guest of Weekapaug. We have another undated photograph here, which shows the overwash of and destruction from the 1938 hurricane. And you can see where the proponents have circled what they claim to be a person walking. This is a photo of a photo. This is not the actual photograph. And they claim there's a person walking here without showing in either picture where Spring Avenue extension is located. In fact, Spring Avenue extension runs very tight along this lot 17 here. We'll get into more of that in just a moment. Spring Avenue extension appears on GIS and tax maps as appearing between lot 17 here and lot 18 here. As such, this is what Spring Avenue extension looks like today. It's overgrown. It's got a stone wall that encroaches upon it by way of an easement. It's got a split rail fence that encroaches upon it by way of an easement. And it has pine trees and other growth that has been there for decades, including a chain link fence that's rusty and old. It's been there since approximately 1978. Proponents make much of old maps. This old map shows Spring Avenue extension located right here in between two private roads, this road being Ninigrid Avenue, this road being Sosoa Avenue. So in the late 1800s, early 1900s, Spring Avenue extension simply connected two private roads. It did not have access to the beach. This is a photograph of the Weekapaug Inn as it was destroyed by the 1938 hurricane. And it was the destruction of the Weekapaug Inn and its relocation farther to the north up Spring Avenue that resulted in a 1939 deed to the town of Spring Avenue north of Ninnegrit. This is critical. There's a deed from the fire district's predecessor, the Weekapaug Beach and Land Improvement Company, to the town of Spring Avenue, beginning at a stone on the northerly side of Ninnegrit Avenue. And you're probably asking, well, where is the northerly side of Ninnegrit Avenue? Can we advance the slide? I got it. The northerly part of Ninnegrit Avenue is right here between the point in this triangle and this lot here. Spring Avenue Extension exists down here. So Spring Avenue north of Ninnegrit was deeded to the town, this stretch of road here, in order that it be made a highway and a bridge be constructed right here so that the Weekapaug Inn could be moved from this location on the beach up to this location on the banks of the pond. You'll note here that Shawmut Avenue and Meadow Avenue are other private roads on this, what is now a 1920 plat that remain private to this day. This map simply shows the new location of Weekapaug Inn here on the bank of Quanaketog Pond, and the Spring Avenue is here, along with the bridge they constructed to meet where the inn is located. It's a long way of saying, had the inn not been destroyed in the 1938 hurricane, we wouldn't be here today talking about the deed of or dedication of Spring Avenue North or Spring Avenue Extension. The whole issue that was being dealt with in the late 1930s and early 1940s was the relocation of the Weekapaug Inn to its current location on the banks of the pond. Okay, this is the third crown jewel of proponents' evidence. This is a 1939 flat map that has that looks very similar to this 1920 map because it's simply a revision of that map. Once again, you see Shawmut Avenue here, Meadow Avenue here, Ninnegrit Avenue down here, Spring Avenue Extension is right here. And there's highlighting that begins right where I described before, the northerly side of Ninnegrit Avenue that extends northerly, where Spring Avenue Extension was being made into a public highway for purposes of relocating the Weekapaug Inn. There are no special markings here along Spring Avenue that show that it was revised in any way in 1939. Now, there are stamps that you can't make out in this presentation. There's a stamp right here by the Highway Commission, and there's a stamp here by the Zoning Board. We'll come back to those in just a moment. This 1939 plat map was recorded specifically in connection with the dedication of Spring Avenue north of Ninnegrit, and we have evidence of that by way of this plat card. The plat card references the deed, which is shown here. So all this was happening in conjunction with the relocation of Weekapaug Inn and Spring Avenue North. There's nothing to indicate that anything was happening here regarding this piece of land, Spring Avenue Extension. This shows that Shawmut Avenue and Meadow Avenue, which we've already talked about, remain private roads to this day in the town of Westerly. That brings us to a 1940 Committee on Public Rights of Way that occurred within Westerly. And you heard me talk about this document at a prior meeting where a 1940 report by a subcommittee appointed by the town council found that there were 11 rights of way to the shore at Westerly, one of which was not Spring Avenue Extension. The town has been deposed, Caroline Contrata's expert has been deposed, and everybody admits that the 1940 report does not list Spring Avenue Extension as a right of way to the shore as of 1940. And in fact, Louis J. Rossi sat on the commission, is the same person who signed this map as a member of the zoning board. He would know if Spring Avenue Extension had been dedicated in 1939 by this map, he would know and have put it on this report. Instead, he signed his name right here, Louis J. Rossi, to this August 5th, 1940 report, which omits any reference to Spring Avenue Extension. Newspaper articles show that the commission, that looked at rights of way, looked within Weekapaug and Misquamicut, among other places, to find rights of way to the shore. So we don't have to guess. That 1940 report was comprehensive, according to these contemporaneous newspaper clippings. So proponents' first theory is statutory dedication. The proponents not only oversimplify the requirements of the statute, 1923 statute, they omit some of them. They also rely on non-existent presumptiveness. The Rhode Island Supreme Court, in the case of Snyder v. Town of Westerly, 1964, has confirmed the 1923 statute did not apply to any and all recorded plats, only those where the platter intended to avail himself of the statute. And there's no evidence that the Weekapaug Beach and Land Improvement Company or the Town of Westerly intended to subject the 1939 plan to the statute. In fact, if the Town of Westerly filed that plan, it doesn't come under the statute at all. We have to go through the statute, and I'll do this as quickly as we can. First, the street or way has to be approved before the plan is accepted for filing the record by the town clerk. Provided, however, that nothing in the statute shall apply to any plan made, approved, or adopted by or pursuant to due action of any public authority. So if the town is the one who recorded the plan, the statute doesn't apply. And proponents have given us no evidence that the town was not the one who recorded the plan. In fact, the town had already owned Spring Avenue north of Ninnegrit by the time the plan was recorded. Section 2 says every plan to dedicate a road or way shall include a profile plan of said proposed street. The Supreme Court in Snyder agreed that the profile plan is a requirement to dedicate. There's no profile plan here. Section 2 of the statute is not satisfied. Section 3 says that the zoning board shall approve the plan after the highway commission, and then the town clerk shall endorse and certify it. The stamps of approval that proponents rely on happen according to this section 3, which means that at this point, the street has not been dedicated. That means the stamps don't have significance as regards dedication or acceptance. On to section 5, which we spend a lot of time on in our brief. At this point in time, the stamps of approval have already happened. The statute goes on and says, upon the filing or recording of any such plan, pursuant to the provisions hereof, such street or way shown thereon shall not be open to travel or otherwise dedicated for public use. It says straight up, shall not be dedicated for public use until such street or way shall be clean of stumps, rocks, ruts, and other superfluous or objectionable material. Work and excavation and embankment shall be brought accurately to subgrade. Corners of intersecting streets shall be rounded according to the direction and approval of the Board of Highway Commissioners. Clearly, requirement number 1 stands on its own and must occur before any dedication can happen under the statute. And this needs to happen after recording the plat per the statute. The statute says that. Finally, section 6 ties the statutory provisions together. Upon filing or recording of such plan and compliances with section 5, such street or way shall thenceforward be a public highway. So after recording the plat and compliance with section 5, the district is not arguing that the stamps are meaningless. The district is just arguing that the stamps did not effectuate a dedication of Spring Avenue extension. And the 1940 report confirms this. Here in 1941, another map was recorded, which has an insert of Spring Avenue extension shown here. This is the insert here, blown up here for your benefit. The highlighted text says, owners of lots shown on this subdivision have a right of way to the Atlantic Ocean over Spring Avenue extension, marked as a 50-foot right of way on insert plan. If Spring Avenue extension had already been dedicated to the public, as proponents argue, there would not need to be a private right of way given to owners of lots shown on this subdivision in Weekapaug over Spring Avenue extension. Going back to section 5 of the statute, we don't have to wonder if it was ever cleared and graded. We have aerial photos. Here's a 1939 aerial photo, again, after the 1938 hurricane washed sand all over the beach. shows shrubs and seagrass here or other obstructions. The proponents superimpose these arrows that point to a parcel that's not even the Spring Avenue extension. Spring Avenue extension is established to be here per our surveying expert. 1948, we have no evidence of clearing. This is the boardwalk path in Weekapaug that runs to the shore across from the bathhouses. There's a sign here that says private beach. There's no evidence of any clearing to the west that would signify a different path so that the public could access the beach. And it would make no sense that there would be a private beach sign here in 1948 if there was, in fact, a public right-of-way over here along Spring Avenue extension. 1950s, Spring Avenue extension exists in this area right here, full of grass and shrubs and trees, no path. 1951, Spring Avenue extension is right here, more of the same. 1963, Spring Avenue extension is in this area. The proponents point to an area that's not the right parcel. Once again, full of grass and obstructed. 1974, same story. Spring Avenue extension is located right here. No evidence of a path. 1985, no evidence of a path. Seagrass and other growth is beginning to take hold in Spring Avenue extension. So let's summarize the statutory dedication argument. What can the proponents prove? They cannot prove that the 1939 plan was not adopted by the town. They can't prove that or reported by the town. They can't prove a profile plan was reported. They can't prove that the Highway Commission approved, followed by the zoning board within 30 days. In fact, the zoning board approved it late. They can't prove the cleaning of stumps, rocks, ruts, or other superfluous or objectionable material per the aerial photos we just looked at. They can't meet the requirements of Section 6. This is all confirmed by the 1940 report. Therefore, there's no statutory dedication available to the proponents. Now, I'm going to touch briefly, I only have a couple minutes remaining. I'm going to touch briefly on public acceptance. As stated in CRMC's own guidance, the intent to dedicate and public acceptance must be clear. Acceptance, as far as acceptance goes, the proponents solely rely upon acceptance by public user. So whether there was intent to dedicate or not isn't relevant at this proceeding. All we're talking about here is whether there was acceptance by public use. Again, that evidence needs to be clear. There's no evidence of public use. The aerial photos show no path on Spring Avenue extension, much less that it was used by members of the general public. Their own aerial photographer found no conclusive evidence of a path over Spring Avenue extension. Let's go into the witness testimony. This is not just us, the lawyers, saying it. You've got now 2+ years of witnesses who've testified that Spring Avenue extension was impassable. The district has witnesses from the 1920s and the 1930s saying things like the extension was never opened as a road. It's never been a means of public access to the beach. It was never opened or used as a road and has always been impassable. The proponent's own witnesses say that if there was a path there, it was less than a foot wide. It wasn't anything marked. Another witness said, at the time he walked on it, he saw the chain link fence and indicated the fence looked like it had been there for a while. This was in the early 1980s. Yes, the fence was somewhat rusted. District witnesses and proponent witnesses confirmed Spring Avenue extension was overgrown with poison ivy and ticks. District witnesses say the Spring Avenue extension was just beach grass in the 1940s. In the 1950s, it was overgrown. There was the Wheaton's house, and where their lawn ended, there was overgrowth to the boardwalk path. In the 1960s and 70s, it was tick heaven. It was covered in beach grass and poison ivy. These are witnesses who gave testimony from the 1920s all the way through the 1970s. The proponent's star witness, Jean Armstrong Sarcosta, testified that Spring Avenue extension had seagrass and ticks and poison ivy. That was in the 1950s. In the 1970s, Kathleen Gray stated, I avoided Spring Avenue extension because I didn't like the seagrass and fear of ticks. This is what we're talking about, whether there's clear use by the public of a piece of land that's described as covered in seagrass, poison ivy, and ticks throughout the duration of history. Another common theme is no one used Spring Avenue Extension without permission. District witnesses said no one walked across that property. Another witness says, no, I never saw anybody walking in the area now known as Spring Avenue Extension. This is from the 1940s and 1950s. In the 1960s, Kathy Wheat said she never saw anybody attempt to walk through the area of Spring Avenue Extension. Proponents' own witnesses say the same thing. Jean Armstrong Sarcosta, again, did not watch the fishermen she thought used the path, did not watch them use the path. She doesn't know how they got onto the beach. From the 1980s, Paul Angelo said, no, there was no other access to the beach other than the boardwalk path. He was a constable for the town of Westerly. So we need to summarize what we see as far as whether there was public acceptance or could be public acceptance under any set of facts. Aerial photos, the possible evidence are aerial photos showing a clear path. No, that doesn't exist. Aerial photos or any evidence showing a reasonably wide path for use and not encroaching upon ticks and seagrass and poison ivy. No. Clear use by anyone without permission. No. Frequent continuous use at any point in time. No. Overgrown for decades. Yes. With grass, seagrass, ticks, and poison ivy. And impassable, yes, by way of the dunes and the fence. Because all these things are true, there was no public acceptance of Spring Avenue Extension. There could have been none, and under any set of circumstances present in this case. I'm going to sum up and then conclude. There's no evidence suggesting Spring Avenue Extension was dedicated under the 1923 statute. There's no evidence of the required road profile. The stamping that's shown occurred before any dedication can occur under the statute. There's no evidence the town or anybody cleaned Spring Avenue Extension of stumps, rocks, ruts, and other superfluous or objectionable material. The evidence definitively shows the purpose of the April 39 revised plan was not to dedicate Spring Avenue Extension, but to dedicate Spring Avenue North as confirmed by the plat card that we showed you. The 1940 report tasked with identifying rights of way in Weekapaug did not find Spring Avenue Extension was a right of way. Aerial photos from the 1930s to the present show Spring Avenue Extension having never been cleaned. Finally, the Spring Avenue Extension can only have been incipiently dedicated if accepted by public use, and there is no evidence suggesting it was used by the public. Witness testimony dating back to the 20s demonstrates it was overgrown, full of poison ivy and ticks. Witnesses testified Spring Avenue Extension was fenced off, impassable, and never open to the public. The only witnesses who testified to using Spring Avenue Extension once or twice had permission to use Weekapaug's property. For all these reasons, which the evidence shows, the subcommittee should recommend to the full council that there is no clear or substantial evidence to designate Spring Avenue Extension as a public right of way. We really appreciate your indulgence in hearing us on this presentation this evening.
Thank you. Any
Are there any
questions?
No.
No? Okay,
Thank you.
thank you.
If I may.
Sure.
On Monday, October 16th, 1939 at 10:50 a.m. a transaction took place at Westerly Town Hall. And that transaction is manifested here where the clerk has endorsed this plat and received it for filing. Under the statute, the 1923 statute, the clerk was duty bound to verify that the plat had been endorsed by way of an acceptance of a dedication by the zoning board of the town of Westerly. And that stamp is right here. The clerk wasn't allowed to accept the plat. Now, I learned in law school that the clerk has to accept anything, but this statute makes an exception. And there had to be this endorsement. I don't call it a stamp, because it's signed. Louis J. Rossi signed it as the secretary of the zoning board. I call it an endorsement because that's what the statute calls it. Now, going above and beyond the requirements of the statute, the Highway Commission also endorsed it. Mr. Farside showed you 3 clauses out of section 5, which is a crucial section of the statute. I agree with him there. But he showed you 3 sections out of that, 3 clauses out of section 5. Clause 1, clause 2, clause 3. But what he didn't show you was the 4th of 4 clauses, because the 4th of 4 clauses is a catch-all. And it made the Highway Commission have jurisdiction over all of the criteria in section 5. So clearing of stumps and rocks was within the purview of the Highway Commission. That's what section 4, the clause 4 of section 5 says. If any of the provisions of this statute, of this section, are not complied with, and that's not an exact quote, it doesn't use the word any. If the sections of this statute or the provisions of this section are not complied with, then the Highway Commission can disapprove. And one of the provisions of that clause is the removal of stumps and rocks. But what the Highway Commission did back in July was to say, we're not going to disapprove it. We're not going to bar it. Don't worry about it, because we've got you, because we consider this to be already free of stumps and rocks. Okay, thanks. Now, this notion that the motive related to a deed of Upper Spring Avenue, that the motive for this transaction was the deeding of Upper Spring Avenue. There's a couple of problems with that. One is that the deeding of Upper Spring Avenue took place 8 months before, back in February. And the deed to Upper Spring Avenue doesn't even mention this plat, and this plat does not even mention that deed. But that's not the biggest problem. The biggest problem with motive is that motive does not matter. Intent matters. I don't doubt, and I have speculated, that the recordation, the filing for record of this plat had something to do with the transaction the previous February. I think that's probably a natural speculation, that there was some kind of connection. But motive is not the same as intent, and the intent was to follow the statute. Otherwise, you would not have submitted it to the zoning board and obtained the zoning board's endorsement, not stamping, but endorsement. There was only one reason to submit a subdivision plat to the zoning board and obtain an endorsement. And that was to follow the provisions of the 1923 statute, which is 1923 Public Laws 538, excuse me. So whatever the motive might have been, the intent was to follow that statute. And to highlight the difference between motive and intent, let me give you a simple hypothetical. Imagine a widow deeds her home to her son. And the motive is so she can qualify for Medicaid, so she can afford a nursing home. But the intent is that her son owns the property, and the son can then turn around and mortgage that piece of property. And another hypothetical might be somebody who deeds the land to a friend or a relative to evade creditors or to qualify or to perhaps qualify for some other government program. So that is motive. It is not intent. The intent was to follow the statute. Now, there's a notion that maybe the town recorded this plat. Okay. The town would not have gone to its own zoning board. There's no other statute that was around at the time that called for the zoning board to endorse plats other than 538. 1923 Public Law 538. So the zoning board, so the fact that they went to the zoning board shows that they were invoking the statute. The town wouldn't have done that. Moreover, there's a whole problem with this speculation that that somehow 538, that is 1923 Public Laws 538, wasn't being followed. And that is this plat, which is the plat that was recorded 2 years later in 1941. And just to orient it, I'll hold it like this. So north is towards the top. Mr. Farside showed you this plat. His version was black and white. My version is based on a color photograph of the plat itself. Here you have the Weekapaug Inn, as you mentioned. The interesting thing about this is that it's endorsed by the zoning board and it's endorsed by the highway commission. And then the clerk acted as gatekeeper. Now, no one, least of all Mr. Farside, has argued that this plat was submitted by the town. This plat was submitted by the Weekapaug Beach Company. There can't be any question. So the idea of private, that the town was somehow responsible for the earlier plat doesn't make sense, as private individuals applying for zoning board approval, or private companies, I should say, follow that same protocol, which is the protocol of endorsement set out in chapter 538. And here in this inset, as Mr. Farside pointed out, you do have the southern part, which is the shore part, which is the original Weekapaug Point subdivision. And that's in this inset, which is up over here. So this goes to the north of what we've been discussing. This fits to the north like pieces of a puzzle. But by endorsing this, two endorsements, the town is re-endorsing the acceptance of this area, since this area is also depicted. And if it had been filled with stumps and rocks, would the town have re-accepted it 2 years later? I mean, consider somebody who applies for a building permit. Building inspector gives the permit, and then they come back for the CO, and the building inspector finds that the electrical is bad, the sewage is bad, the drainage is bad, the foundation is bad, et cetera, et cetera. And he says, I'm not going to give you your CO. Then that same person comes in 2 years later and says, I want to add on an addition onto that house, that same house. The building officer is going to say, well, fix the problems that you already have before I even consider an addition. They didn't say fix the problems you already have. They re-endorsed it. Yes, if I may.
Yes.
Are you saying on that map, that endorsement is endorsing Spring Avenue extension as a public right of way?
I would say yes. This is like the backstop, if you will. I mean, it was endorsed on the previous plat, which is from 1939. Now, 2 years later, we have the same inset here, and they are re-endorsing it. That is what we contend. But certainly, even if they weren't specifying that this area is now accepted yet again, and if the focus was on this area, they still would not have approved it as all A-OK if this were stumps and rocks. So in the presentation that we heard a few minutes ago, the fourth clause, which is the catch-all clause of Section 5, whereby the Highway Commission could disapprove for any defect in the road or any failure to meet the road criteria or the road passability criteria. We had that omitted. But then we had something else that was introduced that is not in the statute. And that is the word after. Now, maybe I missed something. I was reading it again while Mr. Farside was talking. I don't see the word after in the statute. The time sequence that Mr. Farside conjures up is based on the word after, and the word after does not appear in the statute. Now, the word upon does. The word upon does. And if, let's say, a criteria for getting admitted to the bar is upon passage of the bar exam, you have to satisfy character and fitness. Imagine that. Okay, that's a hypothetical. Well, what if I already went and had my character and fitness examination and investigation? Do I then have to do it again? No, it's already been done. It's already all set. So the word upon can, in some contexts, conjure a sequence. In this, it doesn't. My passing of the bar exam sort of relates back, or if you will, my passage of character and fitness relates forward. And by the way, somebody might take the bar exam, flunk, in the meantime, pass their character and fitness, and then take the bar exam a second time, and then pass it, and nobody would say, well, upon passing the bar exam, you have to satisfy character and fitness, because you've already done it in the interim. So the sequence that somehow all of these Highway Commission approvals had to take place later or after just is not in the statute. Now, it does seem that this particular application for a subdivision approval of the roads went through really quick and really easy. I mean, they got the approval of the Highway Commission before they even went to the zoning board. And why did it go through so quick and easy? Well, it doesn't really matter. It's not really relevant. It went through quick and easy. It was done. Oh, and I just have to digress for a moment to this argument about the profiles. It says that you have to submit engineering profiles as part of your application to the satisfaction of the Highway Commission. Well, the Highway Commission has approved. Okay, so if I'm driving along, hypothetical, I get pulled over by a cop and the cop says license and registration, and I give him my license and registration, and he comes back and he says, I'm writing you up for going through a stop sign, and I'm also writing you up for driving without a license. And I say, officer, I can understand the stop sign, but I have my license, I just showed it to you. And he says, yeah, but I think you flunked the eye exam. Now, if there were some shenanigans with the eye exam, maybe revoke my license. I don't know, maybe accuse me of bribery, but you can't say I was driving without a license if I had the license. They had the approval. And that's not evidence, just evidence. It's not merely evidence of having submitted the profiles. It is the complete conclusive act represents that all prior acts necessary were necessarily done as a matter of conclusive law. But why would this have gone through so smooth, so easy? And the answer is something that the council might be somewhat familiar with. I know the previous councils were. Council with I'm spelling COUNCIL, CRMC. And that is as-built permits. This was an as-built application because the pathway was already there. 7 days ago, I received Mr. Farside's motion to exclude my use of 2 photographs in my brief today, and I apologize for the late notice, but today I replied to that. If I could give to council to distribute, I think you have plenty here. There you go. This is my objection to that motion to strike the exhibits. And if I may, and again, sorry for the short notice, I only got council's motion to exclude 7 days ago, but here is the supporting affidavit. If that can be distributed. This path already existed. And here we have a lady in white walking the path in the early 1930s. We have 4, count them, 4 really clear photographs of the path existing in the 1930s prior to the hurricane. Here's the path, there's cars parked, there's still a parking lot there to the day. The path goes through here, it's partly obscured by the brush, comes out here. Here's our lady in white, and this is the beach. The rowboat over here, which is propped off. This alone among the 4, we don't know where it came from, because it came to us through an intermediary, and that intermediary forgot where he got it. All of the other 3 pictures, from the 1930s are from established archival sources. The Westerly Historical Society, the Providence Public Library, and actually from the Weekapaug Fire District itself through their publications. And they all show the same beach, the same vegetation patterns, the same houses, and we've been able to date them by the construction and the permits for the houses that are shown. It was an as-built application, and that's why it went through. Now, it might be said, well, we don't know if this person was a member of the public or was a private owner of a lot on the plat. That's true. That's true. But remember, what we're dealing with here is the stumps and rocks clause and why it went through so easy. It went through easy because this already existed and it was free of stumps and rocks. Now, just this last late summer, a little bit more than a year ago, there was a terrible hurricane in North Carolina. I lose track of the names. Whole roadways were wiped out. Roadways don't even exist physically anymore. But nobody would say that they reverted to private status or they're no longer public roadways just because a hurricane comes through and obliterates it for a short period of time. And it was a short period of time because here we have a picture that we can document as of 1941. And here again, we have a known source, which is a reliable place of custody, which is the Weekapaug Inn. They have a whole bunch of photographs on their wall, all of which we've been able to corroborate, and this is one of them. And this picture, which was taken probably in 41, shows a man or a woman perhaps walking, we don't know which direction, either towards or away from the beach. But moreover, what we see here is this L. And there will be plenty of evidence that there was a shoreline boardwalk, or a cliff walk, if you will, along the shore, rounding the point and junctioning right here. And they made it join up with the Spring Avenue extension. And here, the boardwalk continues onto the Spring Avenue extension. Was there overwash? Yes, there was a hurricane. So when you have a boardwalk that at one time extended to the trolleys that ended over at what is now the Dunes Park location, and people could get on that boardwalk almost there and walk over, I doubt that it was exclusively for the members of this subdivision or the locals, residents of this subdivision. But I would conclude now, because I know I have other counsel that are on my side that would want to speak, by saying that in a way, Mr. Forsythe is right about something. In a way, it is a summary judgment case. It would be a summary judgment case in the favor of the proponents. Because we have three endorsements on the 1939 plat. Thank you.
Thank you. Any questions? Attorney Rubin? Okay.
Mr. Conley?
Yes, Mr. Chairman, William Conley for the town of Westerly. Can I just have one moment may save 10 minutes of argument?
Sure, please.
Thank you. Thank you, I appreciate that indulgence.
No problem.
William Conley for the town of Westerly. I want to begin by saying that town of Westerly adopts all of the argument in its entirety as submitted by Mr. Rubin on behalf of Caroline Contrata in his memorandum, and particularly all the remarks that and the presentation that Mr. Rubin just made to you in regard to the substantial material facts that are in dispute and the application of correct legal principles to those material facts. I say that because sometimes it's a good idea to go back to first principles. And we are before you this evening on the fire district's motion for summary judgment, a summary judgment. Now, the well accepted and well understood standard for summary judgment is that there is no genuine issue as to any material fact. We've just listened to an hour of review of material facts that are at issue in this case, and included in that discussion was not to say argument, but advocacy for what legal principles are at stake and what legal principles apply to those facts. So it's at both levels. It's both as to the facts and as to the law. And I want to emphasize that the summary judgment is a very particular kind of request. It suggests to you that this matter, judgment, ought to be entered on behalf of the fire district in summary fashion. I'm going to go back to that at the conclusion of my remarks, because I do want to talk a little bit about the meaning of the facts that both sides, both arguments have presented to you, and a little bit about what the application of the law to those arguments means in the context of a summary judgment. And it was, I have to say that when you have to start to reach to the idea that a tick infestation should be the basis for a summary judgment, that it really is asking you to go to a bridge too far. Please don't let a tick infestation be the reason why you do not recognize or make a recommendation that Spring Avenue is a right of way. Now, in its presentation, the fire district told you that it relied heavily on Section 5 of that 1923 public law, and they did. They did in their papers as well. And suggest to you that when they call your attention to that, it applies a statutory interpretation to the words in Section 5 that is not supported by any of the canons of statutory construction. And in so doing, in ignoring the plain language of Section 5, or asking you to ignore the plain language of Section 5, it extrapolates from there that the burden of proof in this matter, in this summary judgment proceeding, is about whether or not there were some kind of activity about clearing ruts and clearing the road out, and when the real burden is on the fire district to show that town officials improperly gave their approval to the road that you've seen in both of the maps highlighted to you by Mr. Rubin and referenced by the fire district. You're simply not allowed to shift the burden of proof. In asking you to shift that burden of proof, it doesn't point to any statute that applies, any court case that applies to the 1923 public law that allows burden shifting. It doesn't call your attention to any rule of civil procedure, any rule of evidence. It's essentially just asking you to make a blind leap of faith in statutory interpretation that is not supported by any rule of law. Why? Because the plain language of Section 5 reads as follows: that the street may not be dedicated for public use, quote, it's not reasonably safe for travel, including the removal of stumps, rocks, and ruts as necessary to fulfill the purpose of safe passage. On those words, the fire district is asking you to add additional steps to statutory dedication, which neither the statute, even the Supreme Court case that they cited to you, doesn't call for that. It simply asks you to make that blind leap of faith to say, oh, that's Spring Avenue, that must have needed to be cleaned of ruts. It must have needed to have some kind of affirmative action done to it to make it safe for public travel. But remember what Mr. Rubin told you. It had to go through that statutorily required dedication process. It was endorsed by all of the town officials required to make the endorsement. And as a result of that, accepted by the town clerk. There is irrefutable evidence before you showing you that the Highway Commission is the zoning board and the Westerly town clerk at that time all contemporaneously approved the town's acceptance of Spring Avenue. Next, the fire district went to the 1940 report. Suggest to you that the 1940 report is not the silver bullet that has been presented to you this afternoon, this evening. The suggestion is essentially a negative inference, another blind leap of faith. The negative inference that if this report doesn't include Spring Avenue in 1940, then it didn't exist. Well, the problem with that negative inference is that the words of the report itself tell you that you can't engage in that negative inference. The authors of that report wrote that there seem to be several openings or passageways that may or may not be public rights of ways to the Atlantic Ocean and the tidal waters within the town. It makes no claim to be the period at the end of the sentence. It's the beginning of the discussion. And it tells you that in the plain words of the report. It is not the silver bullet that shoots down Spring Avenue as a right of way. I would suggest in large part that the report's irrelevant. It really doesn't have any meaning in your determination. What has meaning? The meaning resides in the 1923 statute. The detailed process for statutory dedication required by the Rhode Island General Assembly for the town of Westerly. The inquiry need not go any deeper or further than that, and you have it. There was also some discussion in the presentation about the common law dedication and public acceptance. Well, look at our papers. You'll see that the common law dedication dates back to 1886. According to our Rhode Island Supreme Court, common law dedication requires two things: a manifest intent by a landowner to dedicate the land in question, which is called an incipient dedication or offer to dedicate. Number two, an acceptance by the public, either by public use or by official action, to accept the same on behalf of the municipality. Now, despite the misdirection to other information, others, cases that try to suggest to you that there should be something more than that. Look at the cases we cited in our brief. Rubin versus Pelletier, Newport Realty versus Lynch, the Davis case. Look at those cases. Our Supreme Court has said more than one time, that's what we need to show. No burden shifting, no additional elements. That's it. In their papers, the district argues that there's this issue about dual easements, about can Spring Avenue be a private, both private and public? Just discard that whole section. Doesn't mean anything. The existence of a right of way, in this case, the Spring Avenue right of way, does not turn on whether or not Spring Avenue is private or public. The Rhode Island Supreme Court, and therefore the town of Westerly, maintains that Spring Avenue and any other right of way can be privately owned and yet be a host to a public right of way. In fact, when you review the case law in this area, dual easements are at the heart of dedication by plat. That's what they're about. It's well established in Rhode Island law. Again, I direct you to the authority we cited in our papers, that a single tract of land can contain multiple ownership claims, just as multiple liens can exist on any property. The cases in our papers show that Rhode Island courts have long recognized dual easements and are very willing to enforce public rights of ways over roads marked on plats that have been subdivided and sold to different owners over time. That acknowledgement by our Supreme Court in those cases for subdivided land comes from the recognition that a purchaser's belief in the existence of a public right of way often plays an important consideration factoring into the value of that land. But I said a moment ago that I wanted to get back to first principles and what summary judgment is all about. And I say that because I think the ultimate issue before you is whether or not, candidly, you even have jurisdiction to entertain something called a summary judgment. Summary process. In this instance, what summary process means today is that you are being requested to make a decision that is not allowed by the enabling legislation that creates the Coastal Resources Management Council. Call your attention. You are the most familiar people in the state with the statute, but nevertheless, if I may, I want to call your attention to 4623, 20.4. Because that's where the General Assembly wrote, the council may, in its discretion, adopt, modify, or reject the findings of fact and/or conclusions of law, provided, however, that any modification or rejection of the proposed findings of fact or conclusions of law shall be in writing and shall state the rationale. Therefore, that's important. Because what we know is that this subcommittee, has authority to issue recommendations as opposed to decisions, and that there are no regulations that authorize this subcommittee to entertain a summary process. Because what the summary process does, among other things, among short circuit, the dictates that I just read from the statute, it does eliminate public comment. That's really the goal of this. A lot of sizzle, not too much think. Because the goal of this is to thwart that public comment piece. And that public comment, that receipt of that public testimony, that public participation is a core value of the fact-finding process that both the legislature and your regulations require. Why do we know that you don't have the ability to make a summary decision? Well, we cited the cases in our memo. The Champlin's Realty Associates versus Tecoyan, 2010 decision of the Rhode Island Supreme Court. Champlin's Realty Associates versus Kacheri, a federal district court decision from 2006. You're being asked to make a summary judgment when our courts, our state and federal courts have told us that under your enabling legislation, and under your regulations, you are at the recommendation phase of the process. Those cases in our downstream court has told us that the CRMC subcommittee's role is one of gathering facts. Important role. Issuing recommendations. Not to summarily pass judgment, and in doing so, thwart one of the core values of your fact-finding process and eliminate public testimony. That unique aspect of your process is what makes this fact-finding process so special and so important. Don't give it up. Thank you.
Any questions, Attorney Conley? Thank you.
Thank you.
Good evening, Subcommittee. Randall Boots for the state of Rhode Island. I will be very brief because I know we are over. First, I want to just adopt what Mr. Rubin on behalf of Carolyn Contrata had said both orally today and in his briefs, as well as what the town represented by Mr. Connolly said today, and the town and the state filed a joint brief. As Mr. Connolly articulated, and as the brief goes into in detail, a motion for summary judgment is entirely inappropriate at this stage and is beyond the subcommittee's jurisdiction. I believe that Mr. Connolly went into that adequately, so unless you have further questions, I'll move on to my next argument, being that the fire district may disagree with the proponent's interpretation of the facts. They may weigh the evidence differently than we do, and frankly, that's fairly obvious that they would. It's a contested case. That's the point of us being here. With these disputed material facts, it is entirely inappropriate to summarily decide this matter without the hearing, without a public comment, and without both sides putting on the full case that represents what they believe is the truth. We have two sides believing that their truth is 100%. That is for you to decide with it all in front of you, not with a half an hour presentation and then another 20-minute, 15-minute, and hopefully under 5-minute presentation. The subcommittee must hear all relevant facts so that the subcommittee can weigh in and make a determination on those facts so that you can make a fully informed recommendation to the full committee. Thank you.
Thank you. What's next?
Well, first I want to thank the attorneys involved in this matter. Excellent arguments that you heard today. But I'd like to make a few comments, and I'd like to make a recommendation to the subcommittee, if that's okay. So because this is a summary judgment motion, I think the most relevant case is Vacola versus Stop and Shop, 209 A3rd 558, Rhode Island, 2019. And, that case says that the summary judgment is a drastic remedy. And when there are no genuine issues of material fact, the moving party is entitled to judgment as a matter of law. Now, I think what's really going on here is the Weekapaug Fire District is saying you don't have enough evidence to proceed to the public hearing. Because what you've done in the past on these things is made an initial determination as to whether or not there are sufficient facts to go forward and have a public hearing in the community of which the right-of-way exists. Now, as styled as a summary judgment motion, The question is whether or not there are any material issues of fact here. And you've heard conflicting accounts of what is already in your record to date. There has been extensive discovery on this particular right of way. So the question you have before you is whether you think there is enough evidence now in this extensive record to proceed to a public hearing down in the town of Westerly to ascertain additional facts and then make a report to the full council as to whether or not you recommend that this Spring Avenue extension be designated as a public right of way to the shoreline of the state of Rhode Island. That's the issue that you've heard. You've heard some excellent arguments for this. If you feel that there is sufficient evidence to go forward on this, and there are disputed facts, this summary judgment motion should be denied. And if it is denied, I recommend that you set time for a public hearing down in Westerly while the weather's still nice, if that's the way you want to go. If not, that's fine too. But that's, I think, what's in order right now.
So to be clear, there's two motions potentially to,
Two motions by the subcommittee, yes. If the summary judgment motion is not granted, if it is granted, then the second motion is moved.
What about the argument that we're not authorized to make a summary judgment?
Well, you know, there's a merit to that argument. I don't want to get into another case called Banky versus Fine, which allowed another administrative body to grant a motion to dismiss. I think what you need to do is address whether or not you think there's sufficient facts to go forward. Because even though this is styled as a summary judgment motion, the real argument is, hey, you know what? You don't have enough in the record right now to even proceed to a public hearing. I mean, that's what's going on. So I'd ask you to address that and make that determination. If you feel there are sufficient facts to go forward, there are disputed facts, then we don't need to reach the procedural question as to whether or not that's appropriate. Now, if you don't, and you want to address it, then I'll go on to the case law. But I think the predicate issue is important for moving forward on this matter, if that's what the subcommittee chooses to do.
so I would be comfortable. I feel that after listening to, and there have been a lot of excellent presentations and a lot of excellent arguments, and I think that just leads a lot of credibility to the fact that we should find that there's enough evidence at least to move forward and sufficient facts to move forward to a public hearing level on this.
And deny the motion for summary judgment?
And I would support denying the motion for summary judgment.
Is that your motion?
Yes, it is.
I'll second that.
Motion's been made to deny the motion for summary judgment and seconded. Motion was made by Ms. Reynolds, seconded by Mr. Gagnon. Any discussion? All right, I will poll the subcommittee members. Ms. Reynolds,
Aye.
Mr. Gagnon.
I
I too vote aye, for the reasons that were enumerated in the motion by Ms. Reynolds. I am of the opinion that there is sufficient evidence before us to warrant a denial and going forward with the proceedings. So the motion for summary judgment is denied. Next.
Motion to set a public hearing in the town of Westerly. And I know arrangements have to be made.
Right.
Right.
So staff will handle the,
Staff would handle the arrangements.
I don't want to commit to something as long as I can on camera.
Can you announce it later? Okay.
Okay. Do we have that in the form of a motion by the subcommittee?
Yes. The motion. The dates, Westerly for the public hearing.
The motion's been made by Mr. Gagnon. Is there a second?
Second,
Second by Ms. Reynolds. Any discussion? Hearing none, I'll pull the council. Ms. Reynolds?
aye.
Mr. Gagnon? I too, Raymond Poyer, vote aye. Vote is 3 in favor, 0 opposed on the motion to set it down for a hearing date. So I'll take them before us, correct?
That's it. Thank you very much, attorneys. You did a great job.
Thank you. I would entertain a motion to adjourn the subcommittee. All in favor?
Aye.
Aye. Thank you. I will take up 5 minutes.